When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. There are many situations where what is in issue is whether a party has exercised all due diligence or has taken reasonable care or all reasonable steps. Often, what he has been told by someone else may go to that diligence or that reasonableness. The panels discuss this problem arising from the next scenario in the context of an action against a driver of a motor vehicle and also the Registrar of Motor Vehicles. This scenario also raises the problem of the difficulties that can arise when a statement is admitted for one purpose but not for another, difficulties that are multiplied in actions where there is a jury.
Baker, a pedestrian, is run down by a hit-and-run driver. There is some evidence that the vehicle was owned and operated by Harris. Harris denies that either he or his vehicle were involved. Baker sues both Harris and the Registrar of Motor Vehicles. At the trial, the plaintiff calls the investigating police officer.
Did you ascertain whether or not there were any witnesses?
Yes, there was one.
Did he make any statement concerning any party to the case?
Yes, he did.
What did he tell you?
Your Honor, that's clearly inadmissible evidence, clearly hearsay.
Your Honor, I'm merely calling this evidence to prove that a statement was made. I don't wish to prove the truth of the statement. I just merely want to show that there was a statement made at this time.
Well, if that's the case, Your Honor, perhaps the jury should be excused and we could present argument on the point to Your Honor in the absence of the jury.
May I say at the beginning, gentlemen, Section 16 of the Motor Vehicle Claims Act says this: in an action against the registrar, a judgment against the registrar shall not be granted unless the court is satisfied that all reasonable efforts have been made to ascertain the identity of the owner of the motor vehicle and the driver thereof. Mr. Poole?
Well, I think that the evidence by the absent witness is hearsay. I think that it comes within the hearsay rule because I think it's being attempted to be adduced for its truth. And I think it's inadmissible. But because it's an action against the registrar of motor vehicles, and because there's an onus cast on the litigant to exhaust every reasonable channel he can to determine the driver, I think it's admissible on those grounds to be able to show what you've done to try and find the driver before you could join the registrar. But once it's in, if I'm right on those grounds, I don't think it is evidence against either Harris or Baker. It's only evidence, once it's in, against the registrar, and I take the position it's admissible against the registrar because of the statutory requirements.
Professor?
Well, I'd agree with that. It's a statutory requirement, the evidence. You have to produce evidence that you have exhausted all the inquiries. I'd have to agree with that wholeheartedly.
Well, is it only limited to cases against the registrar, or does it not apply to all cases where due diligence in searching for a document or searching for a person comes before the court and the party must show that he has exercised due diligence? Is it not a concept or basic concept of our law of evidence that then the replies received from the people from whom inquiry was made are admissible to show due diligence? What do you say, Mr. Poole?
Well, I think Dr. Mewett rather touched on that this morning, that you're getting yourself, it seems to me, Mr. Chairman, into if I understood your question, you're getting yourself into a situation where you're asking the courts to admit certain evidence for one purpose, then once you get it in, you're using it for another. And I think we're going to get ourselves into trouble if we follow that concept.
Oh, but don't we do that all the time? Come back to our rape case. We say to the jury, this evidence is only evidence of consistent conduct, not of the truth of the fact asserted, and you may consider it only in that regard. I don't worry too much about that.
I worry about that. I worry about that. It's the same as bring in the criminal record of an accused.
What if
excuse me.
Yes, sorry.
I always tell my client when he's accused, if they bring in your record, make sure if they cross-examine you on it, tell them the whole thing because they've got you anyway. And then I can go to the jury and say, the Crown had used the record to show how crooked my client was, but his lordship will have to instruct you, and I try and get the judge on the spot, you see, Mr. Chairman, that when he answered it truthfully, he's the most honest man in the courtroom, including all of us, because he's established his truth here. Don't let me down on that, I tell him.
You know, with respect, I think you're miles off, but you're on a very interesting point. Shouldn't the judge right there and then, as that record comes out, make certain that the Crown Attorney stays right within the statute? That's point number one. Point number two, that he tells the jury that this evidence may be used only for the purpose of credibility and not to show that this man committed the crime or was a bad man and so on. And at the time it goes in, hasn't the accused got the right to a judicial pronouncement or direction to the jury? And shouldn't you ask for it?
Oh, I think everything that you say is right, but what happens when you get into the jury room? They're going to look at his record. They're not going to say, they don't even understand that it's in for the question of credibility. They say, my God, what a crook, and look at all the times he got off. We better get him this time, George.
Well, you know, probably you're touching on a different point, but the American jury studies show that once a man's criminal record comes out, his chances of acquittal depreciate 50%.
Well, that's what I think. I think it's shocking that the court should even allow it.
Well, you'd be in favor then of the English rule that it could only be brought out where he attacked the character of the complainant or some other chief witness.
Yes, as a matter of fact, I think we'll come to that in Canada within the next 100 or so years.
Now, come on back to the other question we wanted to talk about. And to me, I think this is important. Is there not a basic concept in our law of evidence that where an obligation devolves upon a person to search or to make inquiries, surely he's entitled to give the results of those inquiries to show that he has made due diligence and search? What do you think, Professor?
Well, I think you can give the results. The troublesome area, I think, that Bill Poole's concerned with, if I read him right, is that it's when he gives that evidence with respect to what he's done to find the missing witness, and then he starts saying, I was told so-and-so. That's the problem. That may very well be, and I think it is hearsay. Well, but at that point.
But it's, with respect, isn't the whole purpose of the evidence to show that his search was diligent? Now, if you let him say, I went to Windsor, right, and I inquired there.
Smart fellow.
Period, you see. But if he was told, yes, that witness got on board a certain ship bound for Holland 3 weeks ago. Now, therefore, I stopped looking because I checked with that witness and his family, and they'd all seen him leave. They knew that he had his passport. Now, surely that is evidence of due diligence in search and why he didn't go further.
Well, up to that point, it's okay. He says, I went to Windsor. As I say, smart fellow to go there. But after that point, when he starts repeating what he was told, you have no way at all of testing that evidence. And that really is gossip that he's producing in court. That's the worst type of hearsay, I would say.
Well, I may be wrong, but you'll find it set forth in 4 CED at 616, where it's said over and over again that good faith and diligence in search for a document or a person may be evidenced by the replies given to the inquiries. And I'm all alone in that field, I guess, at the moment, as far as you two men are concerned.
Well, I wouldn't.
There is a law, a provision in the Canada Evidence Act, Section 30, subsection 2, in respect to business records, which does suggest that perhaps the common law doesn't extend to negative search generally, where the response is being looked for. Because Section 30, subsection 2, deals with the situation where you look at the business records of a company, for example, and you want to draw an inference from the fact that there is no entry relating to the particular alleged transaction. In other words, you're looking at the records to show that no entry was made and that you'd have expected an entry to have been made if the transaction had taken place. And Parliament obviously found it necessary to make an express statutory provision there, because it provides that the court may, upon production of the record, admit the record for the purpose of establishing that fact, that is, does not contain information, and may draw the inference that such matter did not occur or exist. It may have been put in just from an excessive caution, but it does seem to suggest in business records you should probably produce the record which doesn't have the entry, rather than merely say, I searched the record and found no entry. I don't know. It's an odd section. It's never been used as far as I know.